Hello, good evening, everyone. Good evening, Attorney Father Dan and classmates. We are tasked to report on the continuation of the topic law and government. So, we begin our discussion with the concept of legitimacy. Legitimacy is not specifically defined in the book, but the author related the doctrine of political question and the legitimacy of the Aquino government to better understand the concept of legitimacy. So, political questions are defined as issues dependent upon the wisdom, not the legality of a particular measure. These are questions of policy reserved for the people in their sovereign capacity or issues regarding which full discretionary authority has been delegated to the legislative or the executive branch of the government. So, what do we mean by this wisdom? The Constitution granted full discretionary authority to each branch of the government, each having the wisdom to exercise its powers in its sovereign capacity. The legislative branch enacting laws, the executive implementing the enacted laws, and the judiciary interpreting laws. As a rule, the wisdom of political and economic decisions is outside the scrutiny of the courts. Generally, the courts do not intervene with the internal affairs of the executive and the legislative branch. However, the political question doctrine is not some mantra that will automatically cloak executive orders and enacted laws in legitimacy. If the acts of the other branches of the government result to grave abuse of discretion, it is now subject to a judicial controversy, whereby courts may exercise its judicial power and determine the legality of these acts, whether or not there has been a provision in the Constitution that has been violated. So the under the section 1 of Article 8 of the 1987 Constitution, it defined the judicial power, which includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. So let's move on to the next topic, the legitimacy of the Aquino government. Many challenged the legitimacy of the revolutionary Aquino government. They claimed that it did not observe the proper procedure pursuant to the existing constitution that time, which is the 1973 Constitution. So the courts held that the petitioners have no personality to sue, and their petitions state no cause of action, for the legitimacy of the Aquino government is not a justiciable matter. It belongs to the realm of politics, where only the people of the Philippines are the judge, and the people have made the judgment. They have accepted the government of President Corazon C. Aquino, which is in effective control of the entire country, so that it is not merely a de facto government, but in fact and law a de jure government. Moreover, the community of nations has recognized the legitimacy of the Aquino government. All the 11 members of the court, as reorganized, have sworn to uphold the fundamental law of the republic under her government. So, after the EDSA revolution, no, the 1973 Constitution was abolished. It was followed by the Freedom Constitution, and then later on, the 1987 Constitution was ratified by the Filipino people in a nationwide plebiscite. So this was recognized as an act of affirmation, converting the revolutionary government's authority into a fully established constitutional legitimacy. The Aquino government has gained recognition by the international community, further affirming its status as the rightful government of that time. And also, the Supreme Court ruled no, that the Aquino government is not merely a de facto government, but in fact and law a de jure government. The Aquino government was recognized as one having legal authority and rightful title, and one that exercises power and control over the state. To sum it up, legitimacy is the acknowledgement of the lawfulness and moral justification of the law or authority. So moving on, the Constitution. The Constitution is a fundamental, paramount, and supreme law of the nation. Basically, the Constitution is the foundational principles governing a nation. It is paramount, which means it is of highest importance, and it is supreme, meaning all laws, orders, ordinances are subordinate to it. The Constitution prescribes the permanent framework of government, organizing it and regulating, distributing, and limiting the functions and powers of its different departments. If we were to equate a country to a corporate entity, it would be apropos to say that a constitution is akin to a corporation's article of incorporation and bylaws, since it delineates corporate powers and functions, as well as prescribes the qualifications, rights, and duties of its corporate officers. In the same vein, it is considered a nation's fundamental charter. The Constitution delegated five major powers to the Congress, the President, the Judiciary, the Constitutional Commissions, and local government units. The framers of our Constitution adopted the American type of constitutional government where the written Constitution is interpreted and given effect by the Judicial Department. So let me read this quote. The Constitution is the shore of legislative authority against which the waves of legislative enactment may dash, but over which they cannot leap. So, someone has said that the powers of the legislative department of the government, like the boundaries of the ocean, are unlimited. In constitutional governments, however, the powers of each of the department are limited and confined within the four walls of the Constitution or the Charter, and each department can only exercise such powers as are expressly given and such other powers as are necessarily implied from the given powers. So we have here the case of Kilos Bayan Incorporated versus Ingona Jr. The facts are as follows. Sometime in March 1993, the Philippine Charity Sweepstakes Office, the PCSO, was interested in operating an online lottery system. After knowing this, Berhaya Group Berhad, a Malaysian company, organized the Philippine Gaming Management Corporation or the PGMC to offer technical and management services to PCSO. PCSO issued a request for proposal for the leased contract of the lottery system. Kilos Bayan, a non-stock civic corporation, filed a special civil action for prohibition and injunction, arguing that the contract violated the PCSO's charter and was in reality an illegal joint venture. Petitioners claim that the assailed contract violates Section 1 of RA number 1169 as amended by Batas Pambansa Bilang 42, which prohibits the PCSO from holding and conducting charity sweepstakes, races, lotteries, and other similar activities in collaboration, association, or joint venture with any person, association, company, or entity, foreign or domestic. PGMC is 75% foreign-owned and controlled corporation and cannot therefore be granted a franchise for that purpose as per Section 11, Article 12 of the Constitution. PGMC claims it is only an independent contractor and not a co-operator of PCSO's lottery franchise. It argues that the lease contract does not violate RA 1169 since PCSO, as a corporate entity, has the authority to enter into contracts needed to carry out its functions. So the issue is, did the contract of lease violate or contravene the exception in Section 1 of RA 1169, which prohibits the PCSO from holding and conducting lotteries in collaboration, association, or joint venture with another? The Supreme Court ruled that the contract of lease was invalid for being contrary to law. The court found that the contract was not a simple lease, but a crafty device to hide a collaboration or joint venture. The Supreme Court granted a petition for prohibition and injunction, declaring the contract of lease between PCSO and PGMC null and void for violating the statutory prohibition in the PCSO Charter. So the so-called contract of lease is not therefore what it purports to be. Its denomination, and as such, is a crafty device carefully conceived to provide a built-in defense in the event that the agreement is questioned as violation of the exception in the PCSO Charter. The Constitution is supreme, imperious, absolute, and unalterable except by the authority from which it emanates. Consequently, the powers of the legislative department and all other departments are limited and confined within the four walls of the Constitution or the Charter. If a law, statute, or contract violates any norm of the Constitution, that law or contract, regardless of whether it was promulgated by a government branch or entered into by private persons, is considered null and void and without force and effect. The Constitution is deemed written into every statute and contract. So we have here another case, the Manila Prince Hotel versus GSIS. So the facts are as follows. The GSIS, a GOCC, decided to sell 30% to 51% of the issued and outstanding shares of the Manila Hotel Corporation through public bidding as part of the government's privatization program. So two bidders participated, the Manila Prince Hotel and the Malaysian firm Renong Berhad. Manila Prince Hotel's bid was at 41.58 pesos per share, while the Renong Berhad's bid was at 44 pesos per share. So the Malaysian firm was the highest bidder, hence it was logically considered as the winning bidder but is yet to be declared so. Pending declaration, the Manila Prince Hotel matches the Malaysian firm's bid and invoked the Filipino First policy enshrined under Paragraph 2, Section 10, Article 12 of the 1987 Constitution. GSIS refused to accept the said offer. In turn, the Manila Prince Hotel filed a petition for TRO against GSIS to avoid the perfection or consummation of the sale to Renong Berhad. TRO was granted. Renong Berhad then assailed the TRO issued in favor of Manila Prince Hotel, arguing, among others, that the Paragraph 2, Section 10, Article 12 of the 1987 Constitution needs an implementing law because it is merely a statement of principle and policy. It alleged that it is not self-executing. And then even if said passage is self-executing, Manila Hotel does not fall under the national patrimony. So the issue was, should the Renong Berhad, the Malaysian firm, be admitted as the highest bidder and hence be proclaimed as the legit buyers of the shares? The Supreme Court ruled no, and that Manila Prince Hotel should be awarded the sale pursuant to the national patrimony under Article 12 of the 1987 Constitution. This is in light of the Filipino First policy, which is self-executing. The Constitution is the fundamental, paramount, and supreme law of the nation. It is deemed written in every statute and contract. Manila Hotel falls under national patrimony, and patrimony in its plain and ordinary meaning pertains to heritage. The ascertainment of the meaning of the Constitution begins with its language, employing the plain meaning rule. Words must be understood as much as possible in the sense they have in common use and given their ordinary meaning, because the Constitution is fundamentally a document of the people, not primarily a lawyer's document. However, when ambiguity exists in the phraseology of the law, the intent of the framers of the Constitution must be considered. Courts must avoid literal interpretations that would lead to absurdity, injustice, or unreasonable consequences. So, to sum it up, if the law or the statute is clear, it must be interpreted in its plain and ordinary meaning. But if there is ambiguity in its phraseology, the intent of the framers must be considered. As what Attorney Father Dan discussed in our previous lessons, when strict adherence to the letter of the law would result in absurdity and injustice, the spirit of the law shall prevail. So that's all. Let's proceed to the next discussion.
Good morning, everyone. This is Hensley, at the second reporter. And as for this one, before we begin with my topic, I just wanted to highlight the nature of the Constitution, wherein the Constitution is actually defined as the fundamental, paramount, and supreme law of the land. So, wherein it actually posits on the last part of the 1987 Philippine Constitution, on the preamble rather, it actually states there that the blessings of dependence and democracy, which is under the rule of law and the regime of truth, justice, freedom, love, equality, and peace, do ordain in promulgating this Constitution, wherein the rule of law, which means to say that ours is a government of laws and not of men, wherein the rule should be law with justice, not justice in accordance with the law. For the jura law, may itself be unjust, tested by the standards of super and supra positive laws. And justice must be that conception of right and wrong consistent with the inherent nature of man as rational being, which means to say that the rule which means to say that the rule of law means that laws not on personal whims or emotion, and it should govern society. So it is actually a principle that ensures everyone is treated equally and that no one is above the law, not even powerful leaders. So on the first part, that ours is a government of laws and not of men, this actually means to say that that the decisions should be based on written laws and should not be ruled based on emotions or biases of those in power. So leaders must follow the law just like everyone else. Next slide, please. So, rule of law. So man has yet to invent a better hatchery of justice than the courts. So a hatchery where justice will bloom only when we can prevent the roots of reason to be blown away by the winds of rage. The flame of the rule of law cannot be ignited by rage, especially the rage of the mob, which is the mother of unfairness. So courts are described as the best place we've created to grow and protect justice. So if courts give in to the rage or mob mentality, they risk becoming unfair. So the real test of fairness is whether the courts can protect the rights of even the most unpopular person, especially when society is angry at them. So in summary, laws, not emotions or personal power, should guide on how we govern. Laws must be fair and not just only legal. And also, courts are where justice is not nurtured, but only if they stay calm and impartial. So, True, fairness will grow. True fairness means that protecting everyone's right is even though society dislikes. And next slide, please. So, which means to say that law itself defines power. So, according to the Magna Carta principle, that no free man shall be taken or imprisoned or be diseased of his freehold or liberties, or free customs or be outlawed or exiled or any otherwise destroyed, nor will pass upon him nor condemn him but lawful judgment of his peers or by the law of the land. We will sell to no man, we will not deny or defer to any man either justice or right. So, um, as for this one, law defines power. So this means that the power in the government must come from law, not from personal influence, status, or emotions. So the law itself sets the limits of what officials can and cannot do. So no one, not even the president, judge, or general, is above the law. So as for the Magna Carta principle, uh, as for the Magna Carta principle, it states there that uh, I just wanted to emphasize that no person should be arrested, punished, or lose their property or rights unless it's done through proper legal process, either by a fair trial or by the law itself. So justice should never be sold, delayed, or denied to anyone, no matter their status is. So, in simple terms, everyone deserves free treatment under the law, and courts should exist to protect people's freedom and punish those, even officials, who break the laws. Next slide, please. So, according to Justice Miller, he said that the law is the only supreme power in our system of government, and every man who, by accepting office, participates in its functions is only the more strongly bound to submit to that supremacy and to observe the limitations which it imposes upon the exercise of the authority which it gives. So, according to Justice Miller, he said that the highest authority in a democracy. sa- uh, According to Justice Miller, he said that the law is the highest authority in a democracy. So anyone who holds public office must respect the law even more because their power actually comes from it. So they must follow the rules and not abuse their position. And according to Justice Matthews, that the very idea that one man may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another seems to be intolerable in any country where freedom prevails as being the essence of slavery itself. So, according to Justice Matthews as well, he emphasizes that no person should be forced to depend on someone else's will for their life, livelihood, or basic rights. So that kind of control is like slavery and it has no place in the society. And then, uh, next slide, please. So, before we proceed with republicanism, I just wanted to highlight that I just wanted to summarize the things that I've said in regards with the rule of law is that no one should be above the law because ours is a government of laws and not of men. So, as for this one, uh, I just wanted to uh, proceed with the next topic, which is republicanism. So, what is actually republicanism? So, republicanism is a form of government where citizens have the right to participate in how the country is run. So, it means to say that public affairs like making laws, choosing leaders, and shaping policies are open to everyone and not just a privilege of a few. So, um, So, republicanism of all organic laws of our country, the 1987 Constitution holds most sacrosanct the people's role in governance. So, the word democratic was added to Republican in Article 2, Section 1 of the Constitution as a pardonable redundancy to highlight the importance of the people's role in the government. So, which means to say that our our Republican government is built on democratic principles, where we elect leaders to represent us, and also the power of the government comes from the people. So, citizens are the source of authority, not the president, not anyone, but people. So, it operates under the rule of law, which means to say that no one is above the law. And again, authority comes from the people, not from individual rulers. So, as for this one, the government derives its just powers from consent and govern. So the opportunity of the people to give expression to their views is implicit in the fundamental principle that sovereignty resides in them. So the principle means that the government only has legitimate authority if the people agree to be governed. So power doesn't come from force, fear, or tradition. It actually comes from the free will of the citizens who choose their leaders, accept the laws, and participate in shaping society. So it's actually a core idea in a democratic philosophy that the people are the true source of power, and the government exists to serve them and not the other way around. So in the recent Senate hearing with Senator Tulfo about his statement with bending the law, which he stated, kaya nga po dito po sa mga kontraktor, mga opisyal, isauli ninyo ang pera ng taong bayan. Hindi po batas ang pinag-uusapan and wala ho tayong pakialam sa batas. Mas mataas po ang taong bayan sa batas. Am I right, Secretary Remulla? To which Remulla responded in affirmative. So, does the law bend according to what the people need? And the question here is there a contradiction between the rule of law and republicanism? So, according to Attorney Father Dan, so if the law bends too easily to popular will or political discretion, it creates a slippery path sloping towards possible abuse of power, flourishing in an ambience of unpredictability, instability, and nepotism. So while in democracy, ultimately rests with people, a legal system cannot rest on fluctuating public sentiment. So the cry of the people must be substantiated, verified, and closely examined if it truly reflects the salus populi suprema lex, wherein the welfare of the people is the supreme law. So, as for this one, does the law bend according to what the people need? My answer would be yes, but only through lawful and democratic processes. So, laws are not actually static, so they evolve to meet the changing needs of society, in which evolution happens through legislation, judicial interpretation, and constitutional reform. However, this flexibility must follow legal procedures and not emotional appeals or mob pressure or arbitrary decisions. In short, law adapts, but it does not bend recklessly. It must remain grounded in justice, fairness, and due process. So there's actually no inherent contradiction between the rule of law and republicanism. In fact, they are deeply intertwined and mutually reinforcing. So how do they work together? So, as what I've mentioned, rule of law ensures that laws govern society, not arbitrary decisions or personal power. It actually protects individuals from domination, abuse, and unfair treatment. So, it actually requires that laws be publicly known, fairly applied, and equally enforced, wherein republicanism It emphasizes civic virtue, public participation, and the common good. And it also advocates for a government where citizens actively shape laws and hold leaders accountable. So, this actually seeks to prevent arbitrary domination by ensuring that power is exercised through lawful and representative institutions. So, why do they actually align? So, modern Republican theory, especially as developed by the thinkers like Philip Petit, argues that freedom means non domination and that the rule of law is essential to achieving this. So, in a republic, laws are created through democratic processes. Power is limited by legal framework, and citizens are protected from arbitrary rule. Thus, the rule of law is just not compatible with republicanism. It is too central its vision of liberty and justice. So, to summarize, republicanism provides the moral and civic foundation of law, and the rule of law provides the structure and safeguards the republican ideals. Together, they ensure a society that is free, fair, and governed by reason, and not by force or favoritism. So, as for this one, I just wanted to highlight that in the next uh topics, since we've mentioned that no one is above the law, and republicanism actually simplifies it. We elect someone to represent us. But in the next topic about public accountability, or how do we make these elected officers be publicly accountable with their actions that is not under the rule of law, and and it violates the core ideas of republicanism and democracy. So that would be all, and thank you.
So we have finally reached to my two topics, which are public accountability and democracy. Two of which I think are not talked about enough, not stressed about enough. You know, we talk a lot, we talk about it a lot, but do we really know what these two words mean? These two words are basically or essentially the foundations or one of the foundations or tenets of a public officer in a government. So let's start off with the public accountability. So, public accountability, what is it? It is essentially public trust. All public officers and employees must maintain and hold. It is service with utmost responsibility, integrity, loyalty, and efficiency. It is as well action with patriotism, justice, and the leading of modest lives. This principle has been oft repeated by the Constitutional Court in a long line of cases, and the exhortation still applies, especially today. Uh, Next slide, please. It is enshrined in one of the cases in, in Field Financial Operations Division versus Lucio, where it states, time and again, we have stressed that all those involved in the administration of justice must faithfully adhere to, hold, inviolate, and invigorate the oft stated principle that a public office is a public trust, that all public officers and employees must at all times be accountable to the people and perform their duties responsibly with the care and diligence that the nature of those duties demands. A public servant is expected to exhibit at all time the highest degree of honesty and integrity and should be made accountable to all those whom he serves. It is also enshrined in our Constitution in Section 3 of Article 9B of our 1987 Constitution. The Civil Service Commission shall strengthen the merit and reward system, integrate all human resources and development programs for all levels and ranks, and institutionalize a management climate conducive to public accountability. So, sum up public accountability. Uh, Public office is public trust, and the conduct and behavior as off as it is oft repeated um, should be circumscribed with the heavy burden of responsibility, accountability, integrity, uprightness, and honesty, may it be from the president, a presiding judge, or the lowliest utility worker. So, public accountability is trust. Now, to put it in a nutshell. And the next topic is democracy. Democracy is defined as a form of government in which the sovereign power resides and is exercised by the whole body of free citizens directly or indirectly through a system of representation. It is distinct from other forms of government such as monarchy, oligarchy, and aristocracy, in which the three mentioned forms of government, ha- their power lies in the select few, as opposed to democracy. It is the entire body of free citizens that has the power. So, democracy versus republicanism. The Philippines is an example of a democratic and republican state. Sovereignty resides in the people, and all government authority emanates from them. That's what we continuously hear in the classes, that the power continuously emanates from the people. And republicanism simply is the notion that the state derives its power from the people, administered by persons in a representative capacity for a limited period or during good behavior. So essentially, the main difference between democracy and republicanism is that democracy emphasizes that the power resides in the people of that country or that state. And on the other hand, republicanism is the form by which it how it administers the power, and it is done through people or persons in a representative capacity. For example, here in the Philippines, that is being shown or done through elections. We vote people to represent us in our different provinces, cities, and municipalities. Next, please. So here we are given by Kino a case wherein it places emphasis on democracy and the Constitution. It, in this case, emphasizes the equality that is brought forth by the democracy that is protected in our Constitution. In the case of Guido versus Rural Progress Administration, it asks the question: is the land sought to be expropriated commercial and therefore excluded within the purview of the provisions of Act 539? This case involved a case of expropriation of two adjoining lots of a petitioner, partly commercial, with a combined area of 22,650 square meters situated in Rizal, wherein it prohibits respondent with the said proceeding because the land sought to be expropriated is commercial. Next. So the court found merit in the plaintiff's argument. The Constitution did not propose to destroy or undermine property rights or to advocate equal distribution of wealth. or to authorize the taking of what is in excess of one's personal needs and the giving of it to another. The Constitution and social justice does not champion division of property or equality of economic status, but rather guarantees, slide please, the equality of opportunity, equality of political rights, equality before the law, equality between values given and received, and the equitable sharing of the social and material goods on the basis of efforts exerted in their production. So it is probably evident, it's clearly evident that the Constitution protects democracy, which preaches equality of opportunity and political rights, and the other aspects and qualities I have mentioned. It is we are not a communist regime or a government or socialist regime or government, because we are protected by the equality of sharing and the social and material goods on the basis of efforts and not simply just wait and be given. So that is what democracy is, the equality. It protects the equality aspect as being evident in Guido versus Rural Progress Administration. That is the end of my report. Um, uh, I talked about public accountability, which is essentially public trust, and the difference between democracy and republicanism, and the definitions of each. And this has been our report. Thank you for listening. We hope that you learned much from our report, and God bless and have a great day.